Hello, hi. Welcome to You and Your Right, brought to you by Fortuo Solicitors every Monday from 7 p.m. to 8 p.m. You're welcome to this episode. This episode, we're going to delve into issues that might affect you, might affect your friend, your family, or your neighbor. I will treat you to share this video or this broadcast to as many people as you can so that those people might also be educated. I am Patrick Opokubuaten. I work at Fortuo Solicitors. Fortuo Solicitors is a law firm in the UK specializing in specific areas of law like immigration, family, employment, civil litigation, wills, and probate. Every Monday, we come your way with topical issues, updates, and as we always say, it's just for educational purposes. If you happen to have a specific issue in the topic that we are discussing, you can call our numbers on the screen so that we will be able to assist you. We still do initial consultation free of charge just to help the community. This evening, we're going to talk about two important fees when it comes to making an application to the Home Office, wherever it is, whether it is here in the UK or you are making an entry clearance to come to the UK. There are two fees that you must pay before your application will be processed. And in fact, if you are unable to make that payment, your application will be rejected. Those two fees are the visa fee and a fee that we know it to be immigration health surcharge. This topic, the impact of on family when it comes to renewing their visa is very tremendous. It's very serious and crucial because, as we know, or probably you've heard from somewhere, these fees, one of them is already been increased, the other is going to be increased soon. It is good that you educate yourself. It is good that you are aware of it so that if there is something that you can do, you do it now. And as we always do it, every Monday we come your way with topical issues like this, and we discuss it and we educate you so that you know your left from your right when the time comes. This evening, I've got in the studios one of the senior lawyers at Fortress Solicitors, who is going to help, who is going to assist to dissect this particular topic, the impact of the Home Office fee hikes on immigration applications in the UK. I would now bring in our guest for tonight to introduce himself to you so that you would know him probably, but it is best, it might be the first time someone is watching us. So it is good that he introduces himself to you. Lawyer, you are welcome once again to You and Your Right for 12 Solicitors. Welcome.
PK, Lawyer Patrick, as you prefer to be called. I'm very happy to join you for today's program, as we always do it every Monday, 7 o'clock to 8 o'clock, and it's You and Your Right. My name is Lawyer Daniel Coy from Football Solicitors. We've been practicing as immigration solicitors for a very long time. The areas that we specialize in is employment law, family law, civil litigation, wills and probate, and of course, immigration and asylum applications. When it comes to immigration and asylum applications, we deal with all aspects of the immigration rules, from business applications for corporate entities to private matters to family matters. We deal with everything in between, up to detention and bail applications. It's very, very important that when it comes to immigration matters, you get the right expertise for them to assist you in your cases, and especially in this day and age where certain aspects may delve into others. It's very important you are able to instruct somebody who can assist you when it comes to employment and immigration matters, when it comes to family and immigration matters. And we deal with all these areas. The good thing is we offer free legal consultation. So if you have questions, you have things you are not too sure about, you discuss with us, give us a shout. The first initial consultation is free. We will assess your case. We will give you honest opinion on how we feel your case ought to be run. If we feel there's not much that can be done, we will tell you. If we feel there's a prospect for success when we appeal the matter, we will do that. Or when we make a fresh application, we will do that. On a few occasions, we'll tell you probably you have to return to your home country and come back. Whatever it is, we try our best to give you an honest answer as possible. And of course, when it comes to sponsorship license applications for employers and businesses, we also assist. We can assist any individual or any business to obtain the license and to manage the license as well. So sometimes people, the idea is just simply getting a license, but you have to get the license and you have to manage it as well. We do search for individuals as well. So myself at Fortwall Solicitors and the team, like Patrick and other solicitors that we have, these are some of the things that we do. If you don't know, if you've been listening to us before and this is your first time you're listening to us, then you know what we do and what we can do for you. Thank you, Leah PK.
Thank you very much, Lawyer Daniel, for the introduction. And let's go straight into this topic because this topic is packed and we need to make sure that people are able to benefit from it. The impact of these two fees on individuals who want to make an application to enter the UK or for leave to remain in the UK. And as I said initially, there are two main fees: visa application fee and immigration health surcharge. Now, Daniel, can you tell us a bit who are the people who are going to be affected by this increment, and what are the increment, the percentages, and how much they are, and all those things, so that people will know first before we talk about other issues that people need to be aware of. So, who are the people who are going to be affected with this increment,
Thank you very
whether the
much,
visa
Leah.
fee or the immigration health surcharge?
Thank you very much, Leah Patrick. Let me first give a background to this immigration health surcharge issue, because somebody might be joining us for the first time and may thinking, what are we talking about? You'll be surprised to know that there are some people who still feel making a payment for health surcharge, it shouldn't even be the case. And sometimes we have to argue with clients and things like that for them to understand the need and what the law says about this. Basically, the immigration health surcharge was introduced by the government somewhere around 6th of April 2015 to ensure that migrants contribute to the cost of the healthcare provided by the NHS. And since then, we have realized that the government is determined to rake in as much funds or as much money from this scheme as possible. So on the 13th of October 2023, the UK government announced a substantial increase of 66% to the immigration health surcharge, which we believe was been taken to the parliament on the 16th of January. It was meant to take effect on the 16th of January, but obviously the amendment or that had to be taken to parliament did not go in time. So as we speak now, we are looking at it taking effect from the 6th of February 2024. And for the purposes of this discussion, the main thing people need to understand is this is a charge that many people who are making visa applications will have to pay, because according to the government, this is what, or this is their contribution towards the service that the NHS provide to its citizens. And because many people would have contributed prior to immigrants entering into the system, they need to pay upfront for them to join it. So it's important to understand that even though it's called immigration health surcharge, it is not something you can opt not to make payment into and say, okay, I'm going to get private insurance, so I cannot pay into it when I make an application. Clearly, it will not happen. And the most important thing is this payment needs to come in at the time of the visa application. So you cannot say, I'm not going to make it. Anytime you are making an application that qualifies for such an application, such fees, you need to pay the money before the application is accepted during the process. So it's important you do it at that stage, else you may not have a valid application. Your application may be looked at as an invalid application. And if it's an invalid application, you cannot even get right to appeal when it's refused, when it's rejected. So, or even if you have a right to work, it means it can affect your ability to work, considering the fact that the Home Office may be considering at the time. So it's very, very important you get this right. Now, as I said from the beginning of my presentation, the IHS increase is expected to take effect from the 6th of February 2024. So applicants who wish to avoid the increased IHS fee should apply before the 6th of February 2024. It's important that you take notice of the changes or the date that this will take effect. Of course, there may be people who will not be within the time frame that they need to submit the application, but due to the significant increase, they may want to avoid making such payments. Please speak to your solicitor and see how you can go around it, whether it is a possibility to put in your application ahead of time. There are so many people who will be able to put in an application around reason or the other. But of course, sure that you speak to a professional to you through the processes. And before, there's something that many people have asked Lawyer Patrick. The fact is, why is the immigration health surcharge increasing? And the immigration health surcharge has increased in line with the 2019 manifesto commitment as outlined in the Equality Impact Assessment, which states that the increase continues to deliver the 2019 manifesto commitment to ensure that the health charge reflects the full cost to the NHS of treating health charge payers. The increase to the health charge will ensure that the full cost of providing NHS services for those who pay the health charges are covered. So previously, you will realize that many people, whenever you need the services of the NHS, whether you've come in for the first day, the second day, you might not be paying fully because you have just come to the country and you may just have started contributing to the system. They want to make sure that everybody makes this payment. And I don't know whether it's something you want me to discuss before you come in. Who is and what is the IHS increasing to, or who is affected by this increase? It's important people understand that the health surcharge increasing is going to affect students and their student dependents. So anybody making an application for student visa or any student dependents who may have come in into the system previously or who is now trying to come in, this will affect them. Of course, people who make application for entry clearance for youth mobility schemes will be affected as well. And any child under the age of 18 from 470 to get to about 776 a year. So these people, it's important they look at it as well. So for children making an application, it's important they know that they also have to pay the health surcharge. And many applicants who may be applying for family life applications may also be affected. Of course, people who are making skilled worker visa applications will be affected as well. As we know, currently the majority of applicants applying for skilled worker visas may be healthcare visas, and they are not affected, but other ones may be affected. And for those who will not be affected, will normally be the
Hold on,
visitors who are
hold
coming
on,
in.
hold on, Lawyer Daniel. Later on, we will come to those who will not be affected. But before we
Yeah.
go into that debate, let's be practical. Let's be a bit um, streamlined with what exactly is happening. You know, as Lawyer Daniel said, whenever you are making an application for entry clearance to come to the UK, or you are living here in the UK and you're making an application for further leave to remain in the UK, these two fees are very crucial. And you cannot say you will not pay, because if you say you will not pay, is either the application will be rejected or it will be deemed as an invalid application. The fees that we are talking about, some of them has already been increased. Like for example, the visa application fees has already been increased. So if you didn't know that if previously you were paying a specific amount of money for your visa application fee, since last year, October 2023, last year, your application fee has been increased. And at the moment, we are looking forward to, with this new order that has come since um, January 16th, that obviously we are hoping for it to be implemented from the 6th of February. The fees for immigration health surcharge, as Lawyer Daniel explained, are going to be increased. Under 18, they pay IHS. Above 18, they pay IHS. Whether you are doing an entry clearance application to come as a dependent, or even you yourself, you would also have to pay. Whether you are here, live to remain, you would have to pay. Under 18, if previously you were paying within a year or in a year 470 pounds, it means that from the 6th of February, if, as Lawyer Daniel said, 66%, it means that you are looking to be paying over 776 pounds. Over 18 to, if you are paying a year 624 pounds, 66% increment, 1,030. This is how, so it is too huge for people to understand or even to accept, because a family of five, or say even four, at the moment with this increment, if they are making an application, seriously, it is like someone who is paying a deposit on their mortgage. But at the moment, the Home Office or the UK government, they need to make sure that the pledge in their manifesto need to be adhered to. So they are going to increase it. So be careful. One point that Lawyer Daniel made that we need to be aware of and to be careful is, if your visa is expiring, or if you are looking to make an application to come to the UK or to renew your visa, the timelines are very crucial. You might be tempted that you want to dodge this increment and you might make a wrong application, or the application that you obviously would make is going to have an impact on the existing leave that you've got. Because if you don't do the application properly, or you don't do the application on time or in time, it might affect your existing leave to remain that you've got. So we are talking about a big hike in the fees, but be careful. Seek legal advice before you make any type of application just to dodge this particular increase. But then before you I jumped into it, you were going to talk about, obviously we said that most applicants, whether you are entry clearance applicant or you are leave to remain applicant, there is this particular fee that we call immigration health surcharge that you would have to pay. But you made mention that there are some people, for some reason, they are exempted. Maybe you didn't know that you were not supposed to be paying IHS, but today you might know that you're not supposed to be paying. So, can you take us through a bit to let people know that these people or these applicants are not affected by this hike, or they are not even paying IHS?
Thank you very much, Lawyer PK. There is no IHS for health and care workers, visitors visas, those applying under the EU settlement scheme, or for those applying for entry clearance as a fiancé under Appendix FM. Likewise, there is no immigration health surcharge for those claiming asylum or applying for entry clearance or permission to stay under the Ukraine scheme. Additionally, there is no requirement to pay for those applying for indefinite leave to remain or for British citizenship. This is very, very, very important because, Lawyer Patrick, we have had a number of inquiries in the past from applicants who may have jumped ship from one solicitor to the other, and probably the other solicitor would have charged them health surcharge for making an indefinite leave to remain application. I've seen that quite a number of times. It's good to know that for people who are making an application for entry clearance as Appendix FM, will not need the immigration health surcharge either. And then obviously the EU settlement scheme. So if you are making an application for Zambrano, or you are making an application as a pre-settled status or settled status, whether you are a family member of an EU national who needs to make such an application, remember that you don't need to pay the immigration health surcharge. A full list of those who are not affected by the immigration health surcharge, of course, can be found on the Immigration Home Office website. And if you care to know, you can go into it. Remember, there are different loads of visa applications that need to be made. And of course, we will not have time to go through every single type of application. Additionally, people who cannot afford to pay the immigration health surcharge can request for a fee waiver if they have credibly demonstrated that they cannot afford the fee. For this, we will be going into it into details, especially those people who want to make applications under the immigration rules, those people who want to make application for citizenship registration under 18s. So these are people who will normally be able to make an application, or will have to make an application. But obviously, if you are making application for citizenship, even if you're under 18, as I've already said, you don't need to pay the health surcharge. But the fee waiver will is something that we will definitely be looking at in today's program. And Lawyer PK, there is something that we did mention previously. What happens if I do not pay immigration health surcharge? Can you at least expatiate on that front? Because, as stated in the paragraph 34, subsection 4 of the immigration rules, failure of payment of IHS can cause a few issues for the applicant. And of course, we've seen people who want to do that. Just give us a few scenarios and what may happen to somebody who deliberately or thinks that paying the health surcharge is simply not fair, because they are very, 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 very not happy about this immigration health surcharge payment, and they might want not want to make payments, especially knowing that it's even being increased by 66%. That's quite a lot of money. Give us of a background or explanation on what may happen to such people.
Yes, as we said initially, these are two fees that if you would want to make entry clearance or leave to remain and you are not exempted as we listed, you must pay. For example, if you decide not to pay an application fee or IHS because it is too expensive and you think that I am not even going to access NHS, and the reason why they are saying I should pay this immigration health surcharge is because I'll be using NHS. What you are doing to yourself is that, for example, if your leave to remain, it is expiring on a specific date, and you choose not to make an application, if you choose not to pay the immigration health surcharge or the increment in any of the fees, what might happen to your application is that the application might be refused, and the effect of it will be that your employers might say that your visa is expired and you've not renewed your leave to remain, therefore you are going to be dismissed. Again, another effect that you might have if you think that you don't have to pay the IHS or the visa fee because of this hike or because of this increment, it might even affect your continuous leave to remain. Maybe you've had maybe 5 years of leave to remain banked already for you, continuous leave to remain, waiting to get your 10 years and hopefully get your indefinite leave to remain. If you refuse or if you think that it is too expensive for you to make this payment and therefore you chooses not to make that payment, that continuous leave to remain might be curtailed. Therefore, if you banked about 5 years and you are waiting to get into another 5 years to get your indefinite leave to remain, there will be a break. What that will happen to the continuous leave is that when it comes to the 10th year that you think you qualify for your indefinite leave to remain, because of you being recalcitrant and not wanting to pay the IHS fees or the visa application fee, the 10-year continuous leave to remain, the 5 years continuous leave to remain that you would have acquired to get your indefinite leave to remain, there will be a break and therefore you will not be able to. And in fact, you might even start all over again. And as we know, these fees are fees that you must pay because it is an order. You don't pay, the application will be rejected, refused, or deemed as invalid. So it is important that if for any reason you are unable to make that payment, you need to seek legal advice. Because in the second section of this program, we're going to talk about scenarios whereby people are not able to make payment for their home office fees or the visa fees or the immigration health surcharge, that they are scratching their heads. Basically, they don't know what to do because these are fees that they need to pay. You have to stick with us. We're going to go for a quick commercial break. And when we come back, we're going to talk about people who are unable to pay this immigration visa fee, immigration health surcharge fees that at the moment they are going up and up 66%, 15% for and to up to 30% of the visa application fee. Maybe there might be a way for you that you never thought that you could be you didn't know that there was a way, and therefore your application or your visa, it is going to be curtailed or there is going to be a gap in it. We're going to go for a quick commercial break, and when we come back, we're going to ask Lawyer Dan to tell us what can we do if we are unable to pay the visa application fee or and the immigration health surcharge fees that the Home Office are increasing it every now and then. Stay with us. This is the time for you to share this broadcast to your friends and family if you've not done so that they will also be educated. You are watching You and Your Right, and it's brought to you by Fortuos Solicitors. Every Monday, we come your way with topical issues. Stay with us, take a cup of tea. We're going to be right back. Thank you. Watching You and Your Right, and it's brought to you by Fortuos Solicitors every Monday from 7 p.m. to 8 p.m. Today, we are talking about the impact of the Home Office fee hikes on immigration applications. We talked about the fees that you have to pay if you would want to make an application, whether entry clearance or leave to remain, visa application fees, and the immigration health surcharge. Before the break, we were talking about the effect of you refusing to make the payment, those two payments that we've talked about, the immigration fees and the health surcharge fees. Obviously, the repercussions are so deep to the extent that we will not advise anyone just not to pay. Because of that, we are going to advise you, we're going to educate you on if for any reason, genuinely, you are unable to make this payment and therefore the effects of you losing your job is imminent, the effects of you having a continuous leave to remain to be curtailed or broken, the effect of you even not being able to travel home because your leave to remain is being obviously you don't even have leave to remain and you are illegal, but you qualify to make an application. But unfortunately, because the fees are so high, you are not able to make. So this is something that it is possible for everyone to take advantage of. Whether it is the first time you are making an application or you are renewing a specific leave to remain in the UK. This particular bit, if you are unable to make that payment, please make sure that you listen to this bit very, very well, because the increment is inevitable, it will happen. But maybe you might be able to get away with it. What we're going to talk about is called fee waiver. Fee waiver. When we say fee waiver, what it is to an applicant, someone who wants to make an application to come to the UK, and specifically those who are in the UK who are making a specific type of application whereby they need to make payment. Fee waiver is a law, or is an immigration rule that you can take advantage of, so that those two fees that we've mentioned, you that those two fees will be waived for you. But obviously, it is not just going to be straightforward as I have just said. There might be other things that you need to be aware of. There might be other applications that you are even able to make fee waiver application, and others too that you are unable to make fee waiver application. So Lawyer Dan will take us through some of the immigration applications that you are able to make fee waiver applications if obviously you are unable to make those two fees that we just mentioned. So, what are some of the immigration applications that you are eligible to make fee waiver application?
Thank you very much, Leah PK. And it's very important we into the type of applications that this fee waiver can apply to. But for me to do that, it's also important for me to explain what the concept of the fee waiver is, so that our listeners who have never come across it will appreciate and understand what we are really referring to. When we say the concept of fee waiver is basically where a whole amount of your immigration application is waived, or part of it is waived. So you can make an application and will say, okay, simply because you've demonstrated that you will not be able to make payments, they are waiving your immigration fees, or they are waiving the health surcharge alone, because you can pay the immigration fees but you cannot pay the health surcharge, or they are waiving a part of it. The reason why these things are very crucial is that sometimes when you look at it, that oh, you are making an application, the health surcharge for a 2.5 year standard application is £1,560, and you add it to your home office fees, which is about £1,048, you are talking about quite a lot of money. Just imagine that if the applicant is making an application together with a family of three or a family of four, and just multiply these figures together, then we are talking about over £10,000 for such an application. So it is very, 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 very significant that people are able to take advantage of the ability to make such. And it's not even just that. Apart from the cost of making the application and paying the home office fees and the health surcharge, you also ought to think about the cost of paying for your biometric appointment, which is another £19.20 and all that. So these are things that all adds up when you look at the total fee structure of such applications. So when we refer to the Home Office guidance on fee waiver, right based and other specified applications version 6.0, which was published by the Home Office on the 8th of April 2022, it confirms you can make an application for fee waivers for the following in-country immigration applications, where you will be applying from within the UK. And one of them is applications for leave to remain under the 5 year partner route, where you are not required to meet the minimum income threshold because your sponsor receives one or more specified benefits, where you instead need to demonstrate that your sponsor can provide adequate maintenance. There are certain key benefits that if somebody is taken, one of them, a typical example is the PIP, whereby, or when you are a carer, you are recognized as a carer and you are caring for a family member and you are taking carers allowance. All these designated benefits means that somebody making an application under the 5 year partner route should be able to make an application for a fee waiver. When you look at the guidance, it's not necessarily that they have to put you on the 10-year route. No, if you do it and do it properly, you can do it and you will be okay. Applications for leave to remain under the 5 year parent route is also another interesting one. You will look, most people assume that once you make an application for fee waiver under this route, they might put you under the 10-year route. But looking strictly at the guidance, you will be able to make it even if you are under the 5 year parent route and you think you need a fee waiver for some part of your immigration fee. So it's possible that the person may be earning 18,600 pounds to be able to make an application under the 5 year parent route, but the money when the person takes the rent, London rent, UK rent, living expenditure, things like that, and they do all the subtractions and loans and credits the person is living on, there will not be enough for such a person to make an application and pay for the home office fees. So yes, when you look strictly at the rules, the person meets the immigration rules because the person is earning more than 18,600. But that 18,600 is still not enough for that person to live on and pay the fees without becoming destitute. That's very important. Applications for leave to remain under the new 5 year rule being introduced under the private life rules. That is something that you should be able to make an application using the fee waiver as well. So, as we are aware, some people may be able to make an application under the private life rules, and that is also significant. If you are making such an application, clearly you should be able to do that. Then, of course, people who will be making an application for the 10-year partner parent or private life route, where you can claim a refusal of that application will breach your human rights. Any application under that where a refusal will breach your human rights, you should be able to claim the fee waiver. Applications for leave to remain on the basis of any of the human rights claims, so whether it is on the basis of Article 3, medical grounds, on the basis of being who has lost contact, economic or social ties with your country of origin, or somebody. All those applications under the human rights regime will qualify for an application for fee waiver. So that is also important for you to note. And of course, people who are making application for discretionary leave, following refusal of an asylum or humanitarian protection, where your claim of refusal will breach your rights under the Human Rights Act. Applications for further discretionary leave from victims of trafficking and or slavery who have positive conclusive grounds will be able to also make an application for private or for fee waiver. So these are the type of applicants who will be making an application within the UK, who of course can make an application for fee waiver. It is also important to understand that there are certain type of applicants who can make an application from outside the UK and can also make an application for fee waiver, which therefore will go a long way to affect the health surcharge. So if you are making an application to let's say join your parents in the UK, you are making an application to join your child in the UK because you have contact with that child. All these applications are type of applications that you can make an application for fee waiver, but you need to be careful because such applications you need to be able to demonstrate that you'll be able to maintain yourself without recourse to public funds. So if you think that you will not be able to pay the home office fees or the NHS fees, however, you'll be able to maintain yourself without recourse to public funds. If you're not careful, that will be contradictory and might cause problems for you. So these are things that we'll be looking at. Of course, I don't know whether you can make, or you can delve into the circumstances where you can apply for fee waiver if you already have leave to remain. So you might be somebody who is in the country already, you have leave to remain, you're working, but you want to make an application for fee waiver when you are switching or you are making further leave to remain. Lawyer Patrick, do you want to delve into that before we move on to the next stage? How do I apply for the fee waiver applications?
Before we go into that, there is another category of applicants who are also entitled. They are also able to make application for fee waiver. Those are those under 18 who are doing the registration of their British citizenship. So if you are born here, maybe here for 10 years of your life, and you are due to make a registration, you are allowed to make fee waiver application if obviously your parent or whoever is taking care of. So if you are thinking of making that application and you or your parents, obviously your child qualifies and you qualify for fee waiver, think about that too, because that payment is also very huge. Is I think it's about over £1,000 at the moment. So you were saying who can make that type of application? Is that what you wanted me to talk about?
Yeah, I was thinking that if you can delve a little bit into how, I mean, you can make such an application for fee waiver. How do I apply for fee waiver? The practicalities, or the way, the type of forms, the type of information that is required from an individual who is wishing to make such an application. If you can delve into it with a few minutes that we have left.
Okay. Obviously, it's an application for people to make if they are not able to pay the home office fee or and the immigration health charge. But obviously, you have to be qualified. You should be an individual who genuinely you cannot afford to pay the home office fee and or the IHS fees. Again, you have to be an individual who is destitute, meaning that you don't have somewhere to live. You are staying with friends. You are staying in friends' spare rooms. You are also eligible to make that application if you are unable to make the application fee or the IHS. Further, individuals who is also at risk of imminent destitution. Say, for example, you are not destitute at the moment, but if you are to pay the home office fee, the IHS fees, you are going to be homeless within the next 3 months. That individual also qualifies to make that fee waiver application. Of course, if your income is not sufficient to meet your specific individual needs for your child, you can also make that application. As Daniel was mentioned, Lawyer Dan mentioned earlier, there are people who earn money, say 18,600, even 20,000 a year, but they can still not afford to pay the immigration fees or the IHS fees because their income and expenditure, if they pay it, it will show clearly that they are going to be affected. There is an affordability test that the Home Office guidance would have to go through to find out whether you can, in fact, afford it. The affordability test is embedded in the guidance for the caseworkers to be able to determine whether this individual can afford it or cannot afford it based on their individual circumstance. With everything that I've just said, we would have to show evidence to the caseworker or to the Home Office that truly you satisfy that requirement, you cannot afford it, you are going to be destitute, or you are in fact destitute, or your income is not sufficient enough. Some of the evidence that you would be showing to the caseworker or to the Home Office is your income, whether it is employment or self-employment. You have to show that truly your income is not sufficient enough for you to be able to make that payment. They will also be into your assets as well. That is money that you've got available in your bank account, your investment. If you partner, bear in mind that partner will also be linked to the type of application that you're making. Say, for example, you're making a fee waiver application, but it is known that you've got a partner who can afford or who is able to pay on your behalf. The caseworker or the Home Office will say that that individual will assist you. Your accommodation is also very important to bear in mind that if your accommodation is not sufficient or you don't even have accommodation, then you also would have to show that evidence, and that evidence will be in your rent, your mortgage payment, or anything that shows that your accommodation is not sufficient, or even your accommodation is so expensive that if they require you to make the visa application fee or the IHS fees, you are going to be destitute. Some of the evidence that you would have to show, it needs to be physical. You have to have your pay slip to show, in fact, this is how much you earn. You have to have your bank statement to show that this is the amount of money that you've got, and therefore it is not enough for you to be able to pay your IHS or your health surcharge. And as I previously said, if accommodation is so expensive, your rent, your tenancy agreement would be showing all this evidence so that the caseworker would know that you qualify. Fee waiver application can be done, first of all, if you are applying for the first time for leave to remain in the UK, or you are applying to renew. So when you are applying for the first time, you qualify to make a fee waiver application. If the requirements that I've previously mentioned, you satisfy those requirements, you can make an application for fee waiver. Again, if you are renewing a specific leave to remain, you are also eligible to make a fee waiver application. And a fee waiver application, what we need to bear in mind is that it's a specific type of application that you will make. If you don't make that application, don't assume that there is anywhere that you can write on the main application form to let the Home Office know that you cannot afford to pay the application fee or the IHS fee. You can make the application, as I said, if you are a first timer, there is a specific type of application that you fill in. You would have all the evidence that we've mentioned previously to show to the Home Office or the caseworker that, in fact, you cannot afford it. In fact, you are destitute. In fact, there is imminent destitution if they are saying you have to pay your visa fee and or your IHS fees. And in fact, your income is not sufficient enough to meet your child's needs. Therefore, they should waive it for you. All these things will come in place when an application is being made. Don't assume that you can write it anywhere or you can put it anywhere on an application form to say that you cannot. Therefore, they need to waive the fees for you. You have to make the application for the Home Office to assess your specific application, grant your application, or refuse your application. If you've made a first time fee waiver application, don't assume that subsequent renewals are automatic. Every time that you make any renewal of an application, you still have to make an application for fee waiver if you qualify or if you satisfy the requirement for fee waiver, and in fact you cannot pay your immigration fee and or your IHS fees. There is this particular key date that people need to be aware of, because if you miss this particular key date or key timeline, it might affect your leave to remain, the continuous leave to remain. It might affect even your work or your livelihood here in the UK. That is 10 working days. Whether your application for fee waiver is granted or refused, that 10 working day timeline is very crucial. When your application is granted, you have to make another type of application within 10 working days. Other than that, the grant of your fee waiver will be invalid and you have to make the application again. If your fee waiver application for any reason is refused, you have to make an application within 10 working days. Other than that, your continuous leave to remain will be curtailed or it will be discontinued. Therefore, it might affect your continuous leave to remain into acquiring your indefinite leave to remain later on in the years. As we said, it's just for educational purposes. There are so many things that we can talk about when it comes to fee waiver, but time will not permit us to go into it deeply. But if you need further information in relation to you not being able to pay this new hike in immigration application fees, just give us a call. Our telephone numbers are on the screen. Give us a call, have a chat with us so that we will be able to assist you for you to be able to make this application fee and your leave to remain in the UK. Ladan, I don't know whether you've got something to add to what I've just said in relation to the fee waiver application. Other than that, we will just have to thank our viewers, unless you've got something to say.
Not at all. I just want to also thank our viewers, people who have joined us, who are sharing. We appreciate your time and effort. As we said, we have explained the impact these fee increases is going to have on people's applications. And if you are concerned about whether this is going to affect you in any way, you want your application to go in earlier than before the increments will go in, whether you have questions, anything, feel free to call us during the week, Monday to Friday, 9:30 to 5:30. And remember, it's free consultation. Thank you very much for joining us.
Thank you very much, Ladan, and thanks to everyone who obviously watched us from 7 p.m. till now. Always, we will come your way with topical issues like this every Monday. Stay tuned with you and your right, and it's brought to you by Fortress Solicitors. We will see you again next week, Monday. Thanks for watching.